I'm happy to do so. First, let me introduce myself because that perhaps may have some bearing. My name is Mike Carter. I was an attorney for the Hamilton County Sheriff's Department for 19 years. I left that position. I was appointed General Sessions Judge by Governor Donald Sundquist. In 1997, I served there 9 years. Shortly after my appointment, civil asset forfeiture went into effect, where the Sessions Court judges handle the initial hearing. I heard the gentleman, Mr. Bishman, ask earlier, I don't know if there was one prior to that, but I know the judicial involvement of the determination of probable cause occurred about 6 months after I took the bench because at our annual conference we were taught how to handle those. And the statute specifically says exactly what the judge may ask. Sessions Court in Tennessee is not a court of record. Therefore, there is no court reporter or stenographer as there is here today. But every seizure had to be recorded and that sent to the state or the seizure was invalid from the very beginning. Had to be done within 5 days, had to be done based upon the question cited in the statute, and it had to be recorded. I was talking with my fellow judges a few days ago, my former fellow judges a few days ago, when I knew we were going to be here, and we tried to calculate about how many of these I had done in 9 years, and we guesstimated at 3,000. So I've had some experience with that, and if you have any questions, I say that to you so if you have any questions you may want to. Mark Daniel, who is on our panel today, is a good friend, a great legislator, certainly led the charge in this year. He and I, let me speak for myself, not for Mark, he do that himself, believe that there are substantial changes that need to be made to the law to add protections to the number one problem we have is how do you define the person that is not arrested? Are they non-present? Are they innocent? It's very difficult to determine. So in the amendment I ran, we call them non-present owners. Because many of them do end up to be guilty later on, and many of them do not. So the bill that I proposed, which was an amendment to, or the amendment that I proposed, which was an amendment to Representative Mark Daniel's bill, makes a fairly dramatic change in the law, although you may not recognize it as that. If I loan my car to Martin and he is arrested and that car is seized as a result of having drugs or large amounts of money in it, I knew Martin as my friend in the state legislature. He came through while his car broke down. I was happy to loan him my car. I had no idea. My concern with this is once you let people get in the state administrative process, they're hung. I want to triage cases. Those who are arrested and charged with a criminal case, it continues to go as it is. I'm okay with that. Number two, if it's a non-present owner, then it does not go into the state system until a popularly elected judge has had a full hearing to determine what is the basis for that forfeiture. Is there a basis of probable cause? The way we have it now is those cars and money and all that go into the system, and it's the person's obligation to get it back. That's unfair. That's unfair. People do not have lawyers. They do not have attorney's fees to go and force the state to give those things back. Martin did an incredible job in our committee about presenting issues and facts. And one of them, I don't remember who presented it, whether it was Martin or somewhere else, is very indicative of this situation. A gentleman up in Virginia owns a very successful heating and air business. They buy Ford diesel, four-wheel drive, one-ton pickup trucks. I think they had 29. They just had a brand new one hit the shop. It was going in a few days to be racked and all the things they do for their business. His son, having graduated from high school, and 3 other guys wanted to go down to Gatlinburg and park. They did that. They ran a red light or something and got pulled over, and one of the kids in the back seat had quite a bit of weed with him. And so the vehicle was seized. Now, how in the world are we going to say the gentleman from Virginia running a heat and air conditioning business knew or should have known that was there? But under our current existing system, the probable cause to believe that the asset was illegal and subject to forfeiture is it was marijuana, clearly by statute. And then the vehicle transporting it under current law becomes questionable and may be seized. This vehicle cost $77,000. That gentleman made 3 days journeys to Tennessee to obtain the return of his truck. He had assets. He had lawyers. You know what he finally ended up doing? Paid $2,500 to the state just to get his truck back, because he could not continue to spend time and money to do so. The amendment that I proposed said, no. If it's a non-present owner, it doesn't go into the system to have to be retrieved. We need to triage these cases. So the criminals, now, let me say this, I'm not for the abolition of civil asset forfeiture when arrests and crimes occur. What I'm for doing is triaging those cases. And those who, throughout the amendment, I had innocent owner, well, that turned out not to be true when I got into facts. So we ended up with non-present owners. Those people have to go before an elected judge and have a full due process hearing. One of our main problems now, one of the 3,000 things that I did, looking back on, I'm not very comfortable with, and that is all of these hearings are ex parte, meaning you hear only from the police officer. Are you aware that the Tennessee law now prohibits any testimony other than the police officer? There's a Latin phrase that I use frequently. That's nuts. And with an individual owner or an owner not present at the scene, it must be a contested hearing. Now, what was odd about my bill is, or my amendment to Martin's bill, is that we did obtain finally the consent of all law enforcement groups in Tennessee to this amendment. That took a lot of battle. The only 2 things that I didn't get that Martin and I wanted was, number 1, we did get attorney's fees added. Number 2, I wanted to increase the burden of proof from the simple scintilla 51% civil up to clear and convincing in those hearings, and that I could not get to. That is not an amendment that you all have. And if you get a chance to read it, I'll be happy to answer any of those questions. Often, and there are people, very passionate friends of mine, and serious friends I have great respect for, who are adamant that there can be no seizure without an arrest. That is simply the creation of a sanctuary state for drug trafficking in Tennessee. That would be a very bad decision. Why is that? The example that we're given by the Tennessee Highway Patrol, and I've run civil asset forfeiture for the Beacon Center 2 years previously, or 3 years. Mike Bell and I have been fooling with this for years. And 2 things have occurred since then that have changed my position dramatically. DA Trump, who testified, had the area where there was the 2nd most abuses in Tennessee.
Excuse me, we're going to just, if you can just wrap up. I'm sorry
Okay.
that we're so
Oh, well, I'll be short. Chairman Gardner's welcome to have some of my time if you'd like. It's up to y'all.
Well, thank you. Our real problem is we had 2 DAs that needed to be in prison, not in office. They were both thrown out by election. General Crump, I don't know if he's still here. I drive through his district some, so I want to compliment him. Trust me, changing from one DA to another, I have not had a single complaint come out of that district since. So remember that we can create a great law and bad people will destroy it. We can create a bad law and good people will make it work for all parties and do justice. So my concern is that we go back and we triage these people. If they're an arrest, let's let it go like it is now. If you're considering having no arrest at all, let me give you the example that occurred here in Tennessee and is a legitimate example. The Tennessee Highway Patrol got a tip that and I believe it was a UPS truck, would be traveling through Cookeville, Tennessee later that day, carrying Mexican tile, and if you unload it, you're going to find $4.1 million hid in Mexican tile. They unloaded it, began to take apart the stacks, the pallets of tile, and guess what they found? $4.1 million. Now that was someone in Fort Lauderdale had shipped it, and his name obviously was John Smith. The driver of the truck, who had won Truck Driver of the Year several times for UPS, obviously had no idea what was in his truck and even had no right to look in the truck. So In that case, they sent the notice to John Doe or John Smith, whomever in Fort Lauderdale. They never responded, that money was forfeited. That's a forfeiture without an arrest, and I think those need to continue. My concern is not so much about the guilty, it is about the innocent, and that we don't let them get into the system to begin with. Because once you get into it, you're in a morass that only lawyers and big money can get you out of, and then we have two societies, those with and those without, and I'm very much opposed to that.
Thank you. Thank you very much.
Thank you very much for having me here today. My name is John Ray Clemens. I represent District 55 here in Nashville, Tennessee, in the Tennessee House of Representatives. It's certainly an honor to be here with you and an honor to be here with my colleagues, all of whom have done a great deal more work on this and given this issue much more attention than I have in an elected capacity. However, I do represent the people of Tennessee just as they do, and this is an issue of great importance, not only to my constituents and residents, but to every citizen in the state of Tennessee. This is a very serious issue, a civil rights issue, and it's one that I'm not sure it has a right answer, because what we're doing here is we are charged with balancing the rights. The rights of law enforcement and the need for law enforcement to protect our society and ensure public safety. But first and foremost, we have to ensure the civil rights and property rights of our citizens. How far are we going to go before we infringe upon those rights? What are the limits and the necessity that we should place on these types of laws? Now, like any good lawyer, I will defer to a judge, and I will not take up as much time as him here today. And I'm a lawyer, but I have not practiced defense law. I have not handled these types of cases. But I can tell you again, this is an issue of the utmost importance. It is one on which I'm focused with all of my colleagues here today who will talk about laws we've passed in the past several years. We'll put on slideshow presentations talking about the cost of the burdens. We must look at the interest of our citizens first and foremost, and we cannot place undue burdens upon their shoulders with laws that allow unconstitutional takings without due process. I know that the funds used from these forfeitures and asset seizures fund a great deal of our law enforcement. And that is a very large interest, and one that I know our law enforcement takes very seriously, and one, frankly, that they probably need. But we must focus on the citizens of Tennessee and their constitutional rights, and start from there and work backwards to make sure that their rights are protected first and foremost before we start looking at the interest of others. So thank you again for having me here today, and I'll pass on the rest of my time to Chairman London. Thank you.
Thank you.
Thank you, Representative Clemens, and like the two representatives that have spoken so far, both Chairman Carter and Representative Clemens, I've been very interested in this topic for a long time. I'm a private attorney in Sumner County, and before that served as an assistant district attorney, so I've kind of seen this issue from both sides of the aisle. And just as Representative Clemens said and Representative Carter said, you know, I think in Tennessee what we've done over the last several years is get ahead of most of our colleagues out there in other states, and that's in large part due to several different groups that have been invested in this, several different individuals, and quite frankly, Chairman Carter and others, like Representative Daniel, who's more recently amongst our body, but Chairman Carter and I came in together 6 years ago, and we probably worked on this every single year, with him doing the lion's share of the heavy lifting. But there's a number of issues that we've really addressed and I think improved in Tennessee. And that's not a pathway that we're at the end of, but it is one that we've come quite a ways down. And what we have really done is we've tried to improve our procedures and improve our due process procedures that are available to citizens that come into the system. I strongly believe that someone is innocent until proven guilty. That goes through the criminal system. At the same time, there's the disposition of property, if that property is contraband, that we also handle through a process. And I know that's what we're impaneled here today for. So we've tried to improve those procedures just as we protect the rights of those that are accused before we would imprison them or put them on probation or subject them to any kind of fine or penalty. We ensure that they have due process rights. The same is true for property. Obviously, the standards of proof are different. Obviously, the procedures are different. But that's something we've taken great pride of here in Tennessee and tried to continue to improve upon. Not only the procedures, but just as Chairman Carter talked about, we tried to really figure out what that perfect recipe is as far as where the venue would be and who exactly has standing. And a good example of that would be if a husband is arrested for a crime, does the wife have standing? Both of them own a vehicle, so to speak. If that vehicle was seized as part of criminal activity, most of us would love to pretend like we know exactly what our spouse is doing at any given time, but we just don't. We live different lives. The closest marriages on the planet may not know everything about each other. And so you have to deal with situations like that where you have children or family members or friends, or just like what Chairman Carter said, if it's just somebody that's just loaning their vehicle to someone else. And you have to make sure that those folks are protected. And on top of that, ensure, and we've tried to do this, and I think we're doing a pretty good job of it, to ensure that even those that are quite clearly arrested for a crime, that it looks like the law enforcement entities have got them red-handed, that it's just absolutely those folks are guilty of sin. Until they're proven guilty, they're not guilty of anything. They're innocent until proven guilty. So we've tried to build a system that will ensure even those that the public at large may say, well, those are drug traffickers, they still have to have some due process rights and everything else, and we want to make sure to preserve those. If you don't do so, then obviously you can have a system that runs rampant over those that are both guilty and innocent's rights. I will say that just in the past 2 sessions, I pulled 9 different bills that have dealt with this topic here in Tennessee. This has been something, again, we've had robust debate on and quite a bit of movement. We have, again, improved procedures. We've changed around kind of the standing and venue. And we've improved the reporting requirements because this deals with drug crimes, which is what most folks think of, but it also deals with DUIs and terrorist offenses. It deals with kind of everyday run-of-the-mill felonies if they've employed a vehicle or property in that felony. And so there's lots of different categories of this. There's lots of different, pathways in which someone could find themselves in a position where their property may be at risk of being forfeited. So we've looked at all of that. And in some areas, we've even expanded seizures, and in others, we've greatly retracted them. So I will just say this, that in the 9 bills that I looked at just over the last couple of sessions, what I have seen, as far as a theme in Tennessee, is that we have continued to improve upon the protections that every citizen in Tennessee, both the guilty and innocent alike, both the present or non-present alike, would enjoy if their property comes into the system and is accused in some way and is at risk of being forfeited. So I think we've done a good job of improving those procedures. I think we've still got a ways to go. I think there's still some improvements that can be made. But at the same time, I think we pride ourselves in Tennessee of holding those that are guilty of heinous crimes accountable. I mean, if you're going to sell poison to our children here, if you're going to push illegal drugs here, then in large part, if you're guilty of that offense and it's proven that the proceeds from that offense is seized by law enforcement, then you're going to lose that. And the reason for that is that it has a massive deterrent effect. I know everyone on this panel knows this, but it's the profits that these drug dealers are really interested in. They don't care if they lose their product. They do that all the time. It gets stolen, it gets lost, it gets taken. It's very clear what happens to a lot of their product, a lot of the poison that they're pushing out there. But it's their profits that really hit them hard. And so that's the reason it's important to, as far as we are concerned, for law enforcement to focus very clearly on the criminals and the criminal activity and the actual very clear contraband, but at the same time, in instances where they can use some of these drug dealers' money and some of the other issues that I've talked about for the benefit of Tennesseans and to try to improve the safety in our state, and we're trying to build a system that would, again, respect the rights of individuals, create a good process, but at the same time make sure that folks are held accountable that are going to go down that road and going to enter into some criminal enterprise. So again, I'm sure there'll be time for questions later, but without going into specifics of bills, I really appreciate you all having this panel discussion today. Appreciate your time on this very important issue. Thank you.
Thank you. Representative Dan.
Thank you. My name is Martin Daniel. I represent the 18th District of Tennessee, which is West Knoxville. I'm in my 2nd term, and I'm an attorney, but licensed attorney, but I don't practice at the current time. I own a business. But I have a brief presentation via PowerPoint, and the good people who helped me prepare it did omit a few insignificant things, but I believe they got most of it here. And if it's okay with y'all, I'll just go through some of this. I know that if you're here on the panel, you're probably very familiar with this process, but if I may, I'll just glean some of the more important facts from the presentation. By the way, I serve with Mr. Representative Carter on the Civil Justice Committee. Representative Carter is the chairman of the subcommittee. So here in Tennessee, we often pride ourselves in constitutional rights and small government, and how important it is for our citizens to be free and to have a quality, increase in the high quality of life. Often overlooked, however, is the security of property rights of persons within our borders. The government's ability to protect private property is one of the reasons for its existence in the first place, I would submit. The question of whether a particular state government fulfills that role effectively should never be assumed. Interestingly here, it seems that with regard to civil asset forfeiture, the police and the courts are actually acting to undermine the rights of citizens to own and use private property. And for civil asset forfeiture, as Representative Lamberth alluded to, property is taken when there is a probable cause to believe that it's connected to or derived from criminal activity. On the other hand, in order to convict a person of a crime, the standard is beyond a reasonable doubt. In the past legislative session, as Representative Carter alluded to, I carried Bill number 421, which would have made significant changes to the civil asset forfeiture process. Among other things, it would have required criminal conviction before property could be forfeited. There would have been an exception for abandoned property, which I heard some description of property in which often someone does not claim any interest in that. So there would have been an exception in the bill for abandoned property. During the hearings on that bill, we had extensive hearings on that bill, and we determined from the Department of Safety information that 45% of seizures made in 2016 were made without any criminal charges being filed. I submit to you that the current state of Tennessee's forfeiture laws provides a perverse incentive to maximize profit for law enforcement agencies. We as legislators need to safeguard the rights of our citizens. We need to make sure that the proper incentive for law enforcement agents is to protect us and protect our property. Tennessee law currently only requires probable cause for the seizure, and then when you get to the forfeiture hearing, the state must only show by a mere preponderance of the evidence, mere preponderance, 51%, almost a coin toss, that property is connected to or derived from criminal activity. Tennessee allows, as many other states, allows 100% of the proceeds from the sale of assets seized under forfeiture law, and of course cash, to be kept by law enforcement. Strong temptation to abuse the law there, in my opinion. Civil asset forfeiture is big government business, and of course by our hearings we determined that there are no less than 12 persons employed on a full-time basis by the Department of Safety in connection with this program. In 2016, the Department of Safety information revealed that there was $17,299,000 in currency forfeited by persons in Tennessee. Additionally, by way of the Federal Equitable Sharing Program, there were $13 million forfeited. The average size of a seizure, and let me say this, and this is very important, there's been a lot of talk about drug trafficking and cartels and so forth. This information, this stat, disproves that claim. The average size of a seizure in 2016 in Tennessee was $2,200. $2,200. That's hardly cartel money. Clearly, these are not cartels or criminal enterprises that we're seeking money from. Again, over 45% of forfeitures are taken place without a criminal charge. Of course, our good law enforcement officers do play a vital role in our society. However, we as legislators must exercise vigilance and control over this process. I would never say that civil asset, strike that, asset forfeiture should not occur. I simply believe that there should be additional protections placed around this process. Why curb the civil asset forfeiture practice? Civil asset forfeiture is offensive to individual property rights and the notions of due process surrounding that property. I submit to you that the taking of assets without criminal charges or a conviction is prima facie evidence of abuse of this practice. Civil asset forfeiture results in a distortion of priorities in law enforcement agencies. It disproportionately impacts poor persons because they are more likely to live without traditional banking services, and they're more likely to carry cash. Also, they lack the resources to recover assets wrongfully taken from them. Number 4, some of that's been omitted. In my opinion, civil asset forfeiture operates as a stealth tax. Stealth tax on primarily poor persons that funds law enforcement agencies. It is our duty as the legislature to oversee the budgetary process and to oversee agencies. All agencies should be required to come to us, or whoever the local government agency is, and request funds for their operations. Civil asset forfeiture is probably emblematic of big government in our faces, taking our money, violating our individual due process rights. That's one of the primary reasons, in my opinion, we should get rid of it. Or not get rid of it. Let me say that. We should put curbs on a process. And we'll talk more about that in just a minute. Also, 88% of survey respondents in my district favor civil asset forfeiture reform. This is a voter issue. Counter arguments, some of which you've heard. Soft safeguards are in place. We're doing a real careful job. A few cases arise where the owner seeks return. Well, these are actually arguments in favor of imposing additional guardrails around this procedure. If no problems exist, then law enforcement will continue to make the same procedure with the same levels of forfeiting property. Can I have 15 seconds?
Yes.
As Representative Carter alluded to, we have made small changes, and Representative Lambert, within the past 2 years, in my opinion, there have been small changes. We have instituted reporting requirements concerning facts surrounding incidents of civil asset forfeitures. We have persons who have had property seized that may appeal for a review of the taking to an elected judge within 10 days after the seizure. That was instituted or passed this past session. And also, persons seeking a review of the ALJ's ruling may appeal directly to any one of 9 chancery courts located throughout various places throughout the state, thereby bypassing the Commissioner of Safety who would otherwise rule on those matters. We have additional things that need to be done. We need to enhance the reporting requirements, require payments of attorney's fees where there's wrongful seizure of property. We need to always ensure property motive. Proceeds from this program should be directed to the general fund of the state. We should require conviction on criminal charges except where we have abandoned property. We should, I believe that just about covers it. I'm sure we'll have time for questions. Thank you very much.
Thank you.
Thank you. Good morning. I'm Representative Harold Love, Jr., District 58 here in Nashville, Tennessee. Much has been said about the usage of asset forfeiture to curb crime, particularly drug crime. I would submit to you that the war on drugs has never produced a victor in the African American community. Conversely, the war on drugs has systematically decimated the community by creating pockets in which those who would sell drugs would sell them with impunity. They would also engage in other acts that would stereotype our community. As a result, when you have someone who looks like a drug dealer, unfortunately, law enforcement tends to engage them as a drug dealer. And if you happen to have money on you like a drug dealer would, then you get treated like a drug dealer. It's unfortunate that in our state and in our country, an African-American male or female cannot go and retrieve money out of their bank account that they worked hard to save to drive down the street to purchase a car for their grandchild or niece or nephew in cash rather than finance it, and yet be pulled over and then have those assets taken. So when we talk about asset forfeiture, I think we need to address the fact that everybody who's driving around with cash in a car is not selling drugs. Everybody who is driving around into the neighborhood is not engaged in the transmission of those activities. And I think a 2010, maybe 2015 report from the Beacon Center listed out an African-American male who had won the lottery in Georgia. Came back to Tennessee, had $20,000 on him, and then found himself treated unfairly. Also, 2015 report from ACLU in Philadelphia found that 9% of the population is African American, yet 53% of those who had their assets forfeited were African American. This disparity is troubling, particularly when we talk about how, as Representative Daniel pointed to, some in the most underserved poor communities don't have access to banking facilities, and therefore may find themselves having large sums of cash on their persons, and then when they are in transit, find themselves unfortunate victims of those who view them as drug dealers. Let me close with this statement about also asset forfeiture. We have included, I think, acts of terrorism in the need to seize assets. However, let me remind my colleagues, I had a piece of legislation that was drafted out of concern of what happened to a colleague of mine in South Carolina. Senator Clemente Pinckney was shot down, murdered like not a man in his church in Bible study. The young man who did that was headed to Nashville, Tennessee, or rather Tennessee, and out of that concern I brought a piece of legislation to include hate crimes in asset forfeiture. Unfortunately, that bill did not make it out of the Civil Justice Committee. And so when we're talking about asset forfeiture, we're talking about terrorism, let's also remind ourselves that there are other things out there that if we're going to engage in this process should also be included in trying to make our communities safer. Thank you.
Thank you. Representative Carter?
Thank you, and good morning. Appreciate the opportunity to share some of the concerns that I have on behalf of my constituents. I represent the 93rd Legislative District out of Memphis and Shelby County. And I would dare say, whether in Shelby County or across this great state of Tennessee, my constituents are going to be in that group that are more likely to be profiled and therefore more likely to be stopped and therefore more likely to be subject to asset forfeiture laws and policies that we have in place. I think my colleagues have done a fine job in giving you statistics and giving you the legal arguments. I'm a layman, so I'm going to talk to you like a layman. I see this as not only a constitutional issue, whether it's the Fourth Amendment, and we're dealing with due process, we're dealing with the issue of search and the issues of whether or not we're going to look at what essentially is coming down to be a blurring of the lines between the branches, executive, judicial, and legislative. If we allow the administrative branch, as we have in the past, to be able to take on some of the criminal acts and the consequences of criminal activity and blur the line between civil and criminal seizure and forfeiture, then we're talking about violating constitutional separation of powers. If we talk about the abrogation of legislative responsibilities in terms of who appropriates and who sets the budget for the different agencies that we give oversight to, then we're talking about violation of the separation of powers. I see no reason why we would give up the debate and the subsequent funding of our law enforcement, of our prosecutorial agencies, and allow them to go out and essentially perform their duties, whether it's individually or whether it's coming down from the direction of an agency head. But it boils down to a profit motive, which is always the very worst thing in government, a profit motive, which is, it's not just unconstitutional, it just ain't fair. I think if we look at the need for further reform, it's obvious. We need better data and analysis of the data in order to make some of those decisions that we're going to make next year and following years as we tweak what's in place and what we've already done. If we can get data that breaks down the ethnicity and socioeconomic status of those who are suffering through these processes, we know that the least amount of money that you have, the more likely you are to be profiled, because you're more likely to be in a vehicle, and you're more likely to be of the ethnicity that's going to fit that profile. And if someone wants to argue profiling, I'd be happy to argue with you, because I see it every day, and I've been victimized by it myself. I think if we start to get those numbers analyzed and figure out where it's happening, get the data from the officer in the field and why, and how, and we can start to look at a better way of being able to address the issues of public safety. I in no way want to diminish the amount of work that the different agencies have been able to do from the funding that's been secured in the past. But what I do want is check and balances. I want to know that constitutional rights are not being violated while we perform our duties of budgeting and appropriating funds and not leaving that up to the different agencies to go out there and treasure hunt for themselves. It's not fair for our constituents. It's wrong for us to do so. So what I will ask is simply that you will take this information back and tell the federal government, don't get in our way by giving or trying to intimidate us and trying to bully us in ways that are going to keep us from managing those agencies that answer to state government. We're not interested in you being the federal government, taking over the process. We don't want our state law enforcement agencies to be able to go around us and for the federal government to, quote, adopt these seizures and forfeitures. We don't want that. We're the duly elected representatives of the people of the great state of Tennessee. Let us do our job. Thank you.
We will have questions, and we will have time for committee questions. And I'm just going to take chair privilege here and just ask the first, just to follow up with this last point that Representative Hardaway was making. So the question is this, and I know that there are sponsoring representatives on our panel, but with respect to this most recent session and the bill that I believe became Public Chapter 441 in terms of the reporting requirements, the additional elements of reporting that was enacted recently, there in the original bill, there were a few items that were going to be reported, including whether arrests were made or criminal charges brought was one item, and the second was the demographics of the person from whom the property was taken had been an item in the original bill. Both of those items were deleted prior to the final passage, the approval and then passage the enactment of the bill. And I'm just wondering about that, since questions about who is being impacted, communities being impacted, whether low-value seizures are happening disproportionately in some communities over others, just for the kind of legislative oversight to understand what is happening to our citizens in Tennessee. How do we begin to get at that if we don't have that type of data to allow us to analyze it? So I'm asking anyone on the panel who wishes to respond.
Yeah, in Tennessee, every bill must obtain a fiscal note. If it has a fiscal note, it goes behind the budget. That's Latin for your bill is now dated. Currently, that demographic information included in the bill is not being collected. So there was a $435,000 fee to update where it could be collected. That killed all the bill. So would you rather get 90% of what you want or get 0? Now, the changes that are coming will include that information. As you heard the gentleman from Nashville talk about, they already collect that information. So all the new systems are collecting that information. So rather than wait 5 or 6 years and so we couldn't get a bill passed, we got all of that information. As soon as that information is available, it must be reported. So it was a fiscal decision.
I'll say this too. We allocated, I believe, if I remember correctly, about $1.5 million to the Administrative Office of the Courts for a better general sessions database. Our criminal courts and circuit courts already have courts of record. They already record how many folks are arrested, not arrested, what the dispositions are. But by and large, there's a massive number of cases that are disposed of in general sessions court. As Chairman Carter has alluded to previously, there's no record of those. I mean, it's locally, it's kept in the local clerk's office, obviously, but there's no state database where we can actually pull that. That's a major failing, I think, in our system here in Tennessee, and we in the legislature have allocated money towards that. So over the next year to two, that should come online, and that will help significantly in the questions that you have, because that allows us a database to be able to build this into. Some of the best practices as well, and I'm sure the generals may have spoken of this earlier when they were testifying, they are starting to obviously ensure that their drug task forces and police departments are starting to keep that type of data. So the cost that Chairman Carter mentioned, that right now is a barrier to that type of information being collected, very shortly will not be in Tennessee. We're just not there yet. I also sat on a panel that's doing juvenile justice reform, and we are facing some of the same obstacles. It's very difficult to get data from juvenile cases that are by and large handled in general sessions court. So it's not a purposeful omission of that. It's just a matter of money and technology catching up with our desired information.
Well, I guess my concern would be this. Who would the report be going to when the new stuff is added?
It comes to us. Any information we want, it's anybody, it's public, it's to us.
And if Nashville's collecting it, they'll start reporting it immediately.
No, I
So Chattanooga is starting, and so it's already coming. It'll arrive at each individual jurisdiction.
The reason I raised the question because the bill said it would report to committees in the General Assembly. So you're saying that,
Well, it goes first to the Department of Safety,
Right.
and then they report it back to us.
so you're saying that the new stuff that will be added will automatically take that same,
That will be up to each city and each county. If they don't report it, it won't be demanded. If they report it, it will be published.
Representative, then becomes a public
Yeah,
record.
that's right.
That's why we required it to be a report sent to the General Assembly, because it then becomes a public record.
maybe I'm not stating it right. If it was taken out of the current law, and you're saying the bill as written, it was taken out to remove the fiscal note.
Yes.
And now other jurisdictions will report it voluntarily. The data of who is being subject to this, the demographics, right?
Well, what I was told is the federal government now requires it, and that's coming through orders from the Department of Justice, and that's where it's actually coming from. Now, I was told that on the floor. I have no idea of the accuracy of that, but the demographics were essential. If you want to participate in any forfeitures, you must report that. I think that started in 2016. And I think they have a 5-year period to bleed that in so that they can still participate.
So So there's a federal mandate.
That's my, yeah,
Anticipated federal
I'm not
mandate.
representing that as the truth.
Okay.
I'm telling you what I was told,
Okay.
not what I know.
Okay.
Just real quick, regardless of
Yeah,
the
I know
federal
we're
mandate,
gonna-
we're doing this regardless. I mean, again, we've allocated over $1.5 million to a database to be able to keep up with an enormous amount of data from general sessions courts, and obviously there are already some databases out there. We just have to get there. I mean, there's no way to force an elected local clerk to give you information. They're elected locally. So we are trying to build those databases out right now, working with the feds, obviously, and what they need, but at the same time, this is information that as legislators we've asked to and will get. It's just a matter of spending the money to build the databases to do so. Does that make sense? Does that answer your question?
It does, we may come back to it, I want to see there'll be other questions.
Could I
that
get a
we'll
word
move
in
to,
on
but
that before you move
just
along?
1 minute.
And quite simply, this is another instance of where I believe I'm bringing the people's point of view as opposed to a strictly bureaucratic point of view. Collecting the data is fine. There's always three things you can do. You got to figure out how to acquire it, you got to figure out how to analyze it, then you got to figure out how to apply it. And when we get to the point of just getting past the raw numbers of in the field, who got arrested, who didn't, who lost assets, who didn't, et cetera, then we have to look past that and look at those secondary effects, which is who lost their job because they lost their car, right? Who lost the ability to send their children to school properly clothed and fed because they lost their money, who lost their business because their funds were taken and they couldn't pay their bills or acquire inventory. So we've got to look past that initial set of data points and figure out what's the real impact on the citizen, short-term and long-term, by having these. We can sit here and dust with Faraday all we want to, but if we had had the proper checks and balances within the administration, most of this wouldn't have come as quickly or with the intensity that has come to light. If the administration had the checks and balances in place and had been doing their job, then some of these instances of abuse would not have occurred. So for me, back to the citizen, what are the ongoing consequences of having lost their assets? And it takes more than just collecting those numbers and doing that basic review of them. Let's drill down. We didn't do that in the fiscal note, or we could have offset it. I think if we look at the loss of productive days when we can't get to work, or we look at the dollars out of a citizen's pocket trying to pay legal and attorney fees, I think we would have more than offset that little bit of money that it took to collect that data. Thank you.
Thank you. We are going to move to other questions. Daniel Horowitz.
Thank you so much. My name is Daniel Horowitz. I'm a co-chair of this subcommittee. During our last law enforcement panel, we learned that in the jurisdictions affected, only approximately 3% of situations did not, forfeiture situations did not result in an arrest. This question is for Representative Daniel. From your presentation, I believe you said 45% of forfeitures do not have an arrest associated with them. My question is, what accounts for this disparity? Are there wild fluctuations from jurisdiction to jurisdiction as to whether arrests are being made in the context of forfeiture?
I think your question is what accounts for the low percentage of reversals? Is that it?
No, my question is the difference between 45% of cases not having an arrest and only 3% of cases not having an arrest is pretty substantial. We were told by the law enforcement panelists who testified before you that in their jurisdictions, it was only about 3% of situations in which an arrest was not made. That seems
That would
to
be,
be
I would be very surprised if that information is correct. The information I had was, and getting back to where all this data and information, who collects it, it's the Department of Safety. they're charged with administering the civil forfeiture program. So they provided us with the information in connection with the hearing on the bill. I think we had six to 8 hours of hearings on the House Bill 421 last spring. We determined that there were only in 45% of the cases, 45% of the seizures are criminal charges being levied.
Daniel, if I can too, I'm with you, and just in my district, I follow this pretty closely, and I've never seen it go above 5% that are not charged. Now, there is sometimes a disconnect between the Department of Safety and local clerk's offices as far as whether there are charges or not charges, and again, that's what we're trying to improve, is those reporting requirements. But I've always heard, and again, it's not statewide, we need a statewide database for all of this, obviously. But that's what we've been trying to do with these bills that deal with reporting, is to drill down on that number. Again, I have an enormous amount of respect for Representative Daniel. I've never heard of 45%. That blew my mind. I've never seen it go above 5%. Chairman Carter can probably speak to it better.
I think we're confusing our terminology. There is a tremendous number of cases. I only had maybe 5 or 6 contested hearings in 9 years. When people do not appear and contest, Martinsville called that abandoned. No arrest, 45%. You see what I'm saying? So I think that's where you get skewed off. I don't think the attorney generals are counting those where people never make a claim. You don't expect a criminal from South Florida to claim 4.1 million because he's going to the big house for a long time. That would be non-criminal prosecution. See how the figures skew? And I think the district attorney, and I don't know if they're here, but I know that I work so close with the Department of Safety. When they're talking about less than 5% are not charged, they're talking about where there's a contest, not where it's abandoned. So I think both are accurate. I think they're using 2 different terminologies.
Okay, next question, State Representative.
I want to recognize also my representative, Harold Love. But this question is for either Representative Daniels or Carter. The AGL, the administrative law judges that you had in your slide, walk us through that process for recovering your assets. And the reason why I ask is because a lot of the research on administrative law reviews and hearing examiners, a lot of procedural justice literature says that there's an unfair process built into that system. Even among those administrative law judges who have good intentions. Walk us through how does someone go through that process, and how do you provide safeguards to make sure that people are treated fairly, or at times, sometimes people even want to show up. They feel that the process is going to be aggravating against them.
But once the seizure is made, the warrant for the seizure is approved by a magistrate or a judge somewhere. It goes into the administrative process. Now, keep in mind that this year we, in connection with House Bill 813, which instituted additional reporting requirements, we provided that when a person has his or her assets seized, he can ask for a due process hearing to take place within 10 days before an elected judge. So that's an additional safeguard, a little safeguard we instituted this year. So other than that, once it gets into the administrative process, the assets are held by the law enforcement agency. I believe that there are administrative law judges, 2 or 3 administrative law judges that only handle forfeiture proceedings. They would have, if the property owner contests the hearing, contests the taking, he would appear at the hearing before this administrative law judge, and proof would be taken from the law enforcement agents and from the owner of the property. And the standard of proof in those hearings is that by a preponderance of the evidence. So if the state proves by a mere preponderance of the evidence that the property is connected to a criminal activity, it's forfeited to the state. Appeals can be taken from there to the Chancery Court of Davidson County. But there again, we made a slight change in the law this year that provides that the appeals can go to any of 9 venues, Chancery Court venues in the state of Tennessee. So, does that answer your question?
Yeah, the attorney fees for going before a law judge, how does that fall onto the person who's...
There are no attorney's fees provided for. either way.
Yeah, I beg to differ on that, because there was just an award of $15,000 given. But it must be called bad faith, and that is an enormous hurdle to reach. The bill that Martin and I worked on together had a provision, if you win, you shall be awarded attorney's fees. The judge has no alternative. And if you lose all the way up and end up appealing to Nashville Chancery Court, or now one of the new 9 districts, and that chancellor rules in your favor, he or she shall award not only fees for coming into their court, but must go back and retroactively apply all fees from the very day of the beginning. You have to remember, I represent the sheriffs. And let me tell you, if you want to stop this, hit them in the pocketbook. The average seizure in my county last year, Hamilton County got $80,000 out of this entire program. You start handing out $15,000 judgments, you're going to be bankrupt very quickly. Our sheriff, when I saw him the other day, said, listen, I just don't allow any seizure of cash unless they call me. They've got to convince me that I won't end up paying attorney's fees. I said, Sheriff, my bill didn't get through. He said, I know you will next year, and then I'm going to start paying that, so I might as well start now. So it's in effect people doing the right thing. If we pass a great law and we have bad people, it's not going to work. It's like our 2 new DAs have made such enormous changes. I haven't heard a horror story now in about 2 or 3 years, I think, and Vicky would know that's generally where I hear them from.
Okay, thank you. We're going to have just another question or two. We only have a few minutes left.
So we've talked about a few different types of reform. You proposed some that were in your bill this last year. Going back to what Representative Clemens was talking about, when you're having police officers essentially having to raise money to fund their own operations, that's concerning to me that they have to rely on those seized assets to buy uniforms and vests and things that will keep them safe. What is your sense as individual representatives of taking that money, putting it in the general fund of the local government, and then putting the proper impact or pressure on that local entity, the local legislative body, to properly fund our law enforcement rather than to rely on this process to do that funding? And that's for anybody on the panel.
Because we should not allow our rights and responsibilities as legislators to be usurped by law enforcement or any other agency. We have an obligation to have deliberation on our budgetary and appropriations process. And that's why we are elected, to set those priorities and to fund them properly within the statutory and the rules that have been promulgated. So you're exactly right. It's an obligation of our responsibilities as legislators when we don't have that deliberate process, because it not only have agencies out here competing, then it's wrong. And if we can get to the point to where we can bring those funds, and as we've had some bills that allow for them to go into the general fund, that's fine. But how they go out needs to be based upon either merit or need, and those rules need to be set by the legislature.
Thank you. We have time for just one quick question, one quick answer.
Representative Daniel, you proposed that you favor that any funds through forfeiture go back into the general fund. We heard on the earlier panel that would mean that we would not receive any funds from the federal government under its equitable sharing. How would you respond to that issue?
Equitable sharing works this way, it's my understanding. If there's been a seizure and the local law enforcement agency or the Department of Safety wants to hand it off to the Department of Justice, U.S. Department of Justice, they can prosecute the matter, and then they return 80% of the proceeds back to the state. So I think there would be funds received by the state.
They said that those could not come back to a general fund, could only come back to law enforcement. So just seeking some clarity on that issue.
Well, yeah, so I think that direction of any proceeds or any forfeited assets, directing those to the general fund of the state would eliminate the improper motive, the potential improper motive to treasure money.
That might cause a large fiscal note if we're losing those.
Oh, yeah, there's a big fiscal note
Ma'am,
attached to it.
if I may, I think your information is accurate. I think if it's allocated towards something else, then the federal government does not get involved in seizures of criminal assets that do not go directly to law enforcement to, again, improve the safety of our communities, neither do any of the rest of us. I will say that I just personally find it somewhat offensive that you would think that most of our law enforcement officers are out there treasure hunting, to use the word, or trying to pay for their own uniforms or body armor. Most and foremost, that's not what this is. They are out there trying to protect us, and when they come across criminals, we can build a very good process. But to assume the worst of every single law enforcement officer in this state, and just assume that they're chasing down cash because it benefits them, is ludicrous.
Okay.
99% do a very good
What I
job.
may just clear
So-
up was that
Representative
some have
Bennett.
said that
If I may, I would
they need
agree
that
with
money.
him, I would agree. We don't,
Okay.
we're not making that assumption.
I'm sorry.
only trying to eliminate the potential for that practice.
Okay,
And
I'm
with
sorry
that,
that our
I'm not
time
making
is
any
short.
accusations or any
I'm
assumptions.
very sorry, time is short. 10 seconds.
Very quickly, sending money back to law enforcement. The law enforcement then put that money back into the community through programs like Midnight Basketball Leagues to go into those communities where drugs did impact them negatively.
Thank you all. It's been a wonderfully informative panel, and we greatly appreciate your time and you being here. So thank you very much.
Thank you.